The I-140 immigrant visa application is what the employer must file on behalf of the employee. There are three main categories of employment-based applications: EB-1, EB-2, and EB-3. EB-1 cases are reserved for people with extraordinary ability, outstanding professors and researchers, and multinational executives and managers. In the EB-1 category, a labor certification is not required. The employer may file for the employee without a labor certification and can usually immediately file for a green card for the employee at the same time. The EB-2 is reserved for people with advanced degrees and exceptional abilities. Most of these applicants will require a labor certification prior to filing the I-140. There is one exception to this rule, and that is for people who are performing positions that are in the national interest. These positions do not require the labor certification, nor an employer, so the person can usually file the I-140 on their own behalf. The EB-3 application is for skilled and unskilled professionals. This category always requires labor certifications, and therefore an employer must always sponsor an employee for that position. The I-140 immigrant visa application is a very complex process. The attorney must really review with the employer and the employee all the job requirements, the background, the experience of the employee, just to make sure that the best category is picked. And if the person qualifies for a higher category, we want to make sure that the correct recruitment is done for that process.